Okay, we are about to have a phone call with Jim Dumont. And I will just want the committee to know that I did talk to Jim Dumont over the weekend about some of the things that like the areas. This conversation will be back to administration of Act 250, and the proposal that we have decided to pursue. He helped come up with some ideas to help us do that we've given to Ellen, and so he's going to be talking about that when we call him.
Is he a lawyer?
He's an attorney in Bristol.
Again,
He's done a fair amount.
unless you want
of
to. I don't want to do it.
Jim Dumont's office, this is Caroline.
Hi, Caroline. This is Amy Sheldon calling from the Vermont Legislature.
Yeah, hi.
Hi.
Hold on just a second for Jim.
Thank you.
Hello?
Hi, Jim. You are on speakerphone and on the record here in the Vermont House Natural Resources Committee.
Okay.
And oftentimes we do introductions for folks who are on the phone, and I'm not sure you've met our whole committee. We have, I guess, one new member. So we'll go around the room and introduce ourselves for you. Or who's in the room?
I'll start. Chris Bates, Bennington 2-1.
Matt Hill, Lamal 2.
Carol Odie, Chittenden 6-1.
Tom Caranzini, Rutland Town.
Carrie Dolan, Washington 7.
Lee Morgan, Grand Isle County, and the western portion of Milton and Chittenden County.
Paul LaFave of Newark and a good deal of the Essex County.
And also the vice chair, and Amy Sheldon.
Trevor Squirrel representing Jericho and Underhill.
And I suspect Jim McCullough will be rejoining us in a few minutes. So that's who's around the table right now.
Great. Well, how would you like me to proceed?
Well, I guess I just mentioned to the committee that you and I talked over the weekend, and that you had provided us some input on the areas of, I don't know, shared, where we think we need to see improvements in how Act 250 is administered. And so if you want to edify us on your, whatever, share your thoughts on that, that would be really helpful.
Sure. Yeah, during our discussion, what came up was, see, if we're not going to go to a centralized PUC kind of model, but we don't want to have two trials anymore, there's an alternative. And so we talked about what that would look like, and then on Sunday I wrote up drafts of changes to a number of statutes that would accomplish that. So the alternative is to have the district commission hearings be real trials on the record, and the appeals to the environmental division or to the Supreme Court would be just on the record, which means there is no retrial. It's an appeal, and what the environmental court would do is just look at the transcript and all the parties' briefs. So if that's the model, then you have to make sure that the trial that happens, the one and only trial, is a good trial. And so I came up, what we discussed with and what I tried to write up is what we need to change so that we have a fair, reliable, and open process in front of the district commission that would be the one and only trial. So a couple of high points of how you would do that is that every district commission is going to need a lawyer. They're going to have to make rulings on what's admissible evidence, what's privileged, what's not privileged, and you have to have a lawyer advising them to do that. And moreover, they're going to need, I think, professional help to write their opinions so that the opinions will hold up on appeal to the environmental court. So some of the district coordinators are really good at that, but you really need a fair amount of legal training to do that. And since you really need to have a lawyer advise the commission on other matters, it seemed to me you should have the lawyer also helping them write the opinions. And in this model, which is not uncommon, the lawyer is acting as staff to the adjudicative body, so all communications between the lawyer and the body are totally, absolutely privileged. They're essentially the law clerks, the lawyers, and the body is the client. Another necessary component of this is that the canons of judicial conduct would apply to the tribunal and to the lawyer, so that a developer or a neighbor or the governor or a member of this committee can't pick up the phone and talk to the members of the district commission about a pending case. Unfortunately, there used to be a rule that the NRB or the Environmental Board had issued years ago that it was called the Chinese Wall, and it meant that there was a Chinese wall erected between anybody who was making a decision in a quasi-judicial case and any third party. The NRB repealed that rule, and so right now there is that protection does not exist. So again, if we're going to, and of course it exists for judges, because judges are bound by the canons of judicial conduct. So if we're going to take judges out of the trial and have them just review the trial that happens in the district commission, the district commissioners and their lawyer need to be governed by the canon. So I wrote that up. And the third, I think, really important part of this part, I guess the third and fourth parts that are really important are based on the recognition that I talked to some of you about last year that experts are incredibly important in these cases. And right now, the way it works is that the developers have a stable of experts. If the experts don't say what the applicant or the developer wants them to say, then they get another expert until they find one who will support their position. And the district commission, or right now the environmental court, only hears from the developer's experts unless the opponents have a fair amount, or I should say a lot of money, because it's very expensive to hire experts to work in these cases. The way I drafted this is the district commissions have the authority to hire their own experts. Judges have that authority right now, but they can't use it because there's no budget for them to hire experts. The court administrator isn't going to just give them a blank check, and the court administrator is not going to come to the legislature and ask for a budget so the judges can hire their own experts. But if this is going to be a fair process and a process that addresses important public issues, it is important to give the district commissions the authority to hire their own independent experts that are only accountable to them. Related to that is the need for pretrial discovery, interrogatories, requests to produce, and sometimes depositions. That happens right now in the environmental court. The district commissions might have I would say probably do have the authority to order that, but it's rarely done. And it's rarely done for good reason, because right now the district commissions are just a dress rehearsal for the real trial that will happen later in environmental court. So what I wrote up is language making clear that in front of the district commissions can hire their own experts, and there'll be pretrial discovery. If we had all those parts in place, then it would make sense to have the environmental court just act as an appellate body. I think that's the heart of it.
Thank you. Questions? Committee? Representative McCullough.
Thank you very much, Jim, for working on this project that our committee has asked for, or our chair has, and I'm curious about the appellate body. So we had, and you likened on the record at the district commissions with all the experts involved, creating a sufficient record, I think, to be heard later as on the record. Is that accurate?
Yes.
And then the later part for me, I guess I was assuming that it would go should there be an appeal, that it would go, and that's what you just said, I think, then the E-Court would be an appellate body. But I think you also mentioned the possibility early on in your presentation that that's what the Supreme Court hears. Is it reasonable to think that we could be skipping the E-Court and going directly to the Supreme Court with this on the record, or must it stop at the E-Court and then proceed should there be another appeal?
Great question. That is entirely a policy decision for the legislature to make.
Okay.
There's no rule, precedent, or other reason that it has to go through the environmental court first. I think there's some practical reasons why, for example, if the court administrator were in the room with you, the court administrator might say, from the Supreme Court's perspective, they would like to have it go through the environmental court first because it would reduce the number of appeals that eventually reach the Supreme Court. Mm-hmm. But again, that's a policy decision for the legislature to make.
And if we think of what I'm understanding, the joint proposals attempt is to eliminate a step in the appeals process. So if we go for appeals to the environmental court, but it's on the record, it's not eliminating a step, but I'm going to suggest it's eliminating some portion of a step. 0.5 of a step, 0.25, I mean, because it's now on the record instead of de novo. How much more svelte does that make it at that moment?
I'm sorry, your question was how much more?
How much quicker and therefore also less expensive is on the record at E-Court versus de novo?
So I'll answer two questions. How much quicker would it be if you went on the record directly to the Supreme Court as compared to on the record to the environmental court and then to the Supreme Court? And then I'll also answer your question about how much time and energy you save by having on the record to the environmental court as compared to de novo.
Yes.
So I'll answer the second one first. There's a huge, huge difference. I would say the time and energy involved in an on-the-record appeal to the Supreme Court is somewhere between 5 and 10% of de novo appeal. Okay. Most of what we deal with in the environmental court is motions for summary judgment, motions to dismiss, battles over discovery, and the actual time spent where the judge is looking at the merits of the case. That only happens on the tail end. It'll come up in summary judgment motions before then, but this would be a much, much quicker process in the environmental court. Instead of, I think the cost to everybody would be 5 to 10% of the existing cost.
Wow.
Because there's no evidence, there's no cross-examination,
right.
There's no witnesses.
Right.
It's just, what does that transcript show? And you argue about what the transcript shows or doesn't show. And there probably wouldn't even be any hearings because it's all done on briefs.
Yep.
Just like we do you could have oral argument if the environmental court judge wanted to hear oral argument. But in my experience, when I've done on-the-record appeals to the environmental court, which happens in some instances already under zoning, we didn't have a hearing. It was all in the paperwork. Yep. The other question is, how much do you save by going directly to the Supreme Court and skipping over the environmental court? You'd save some of the briefing time and some of the delay. It could save you, I'm guessing, in general, 6 months to a year.
Wow. So, I'm thinking I heard on the record at E-Court could be 90%, as much as 90% faster and less expensive. And that less expensive would also be in time, not just dollars.
Yes.
But skipping that step and going directly to the Supreme Court is another huge time saving over that 5 or 10%. I'm not getting that correlation.
Yes, so I think the briefing would be very similar, so it wouldn't, I don't think there'd be a lot more lawyer time, but just the process of getting it docketed in the
Okay.
intermediate court,
Okay.
getting the transcript, writing the brief, writing the opposing brief, writing the reply brief, and the judge making a decision,
Yep.
all of which has to happen before you can go to the Supreme Court. That will take a minimum of 6 months
Yep.
in most cases, and it
Okay.
could be a year.
Yeah. Okay, I got it. Thank you.
Other questions from the committee? Representative Lefebvre.
Thank you very much for looking into this for us. My question mainly is, how would your proposal impact either public participation or public access into the project being discussed in front of the district commission? Do they have any place, or would it all be very legalistic?
Well, they should have a place. I think right now, in large part, they don't, because everybody knows it's just a dress rehearsal. It's not the real thing. So if this change were to happen, I think it would be much more open to the public, more accessible than the existing system. This system is a courthouse, and it's a judge with a busy schedule, and both judges, I think, do a great job of being courteous and open to members of the public who are pro se. But they're in the courthouse, and it's time away from work and all that. So if the real trial were at the district commission level, and we have members of the community with the guidance of a lawyer helping them make their decisions, I think it's going to be less intimidating, and more people will participate because it really is the main event.
Yes, thank you.
Jim, this is Amy. I'm wondering how many different district commissions you have been involved with over the years?
Primarily Addison, Rutland, Addison, Chittenden, and Windsor.
I'm asking because I'm wondering about your perceptions of depending on volunteers and their availability, and there's been some testimony that the projects have become more complicated over time, and that maybe we're asking too much of them, although I don't think we've heard that from any district commissioners.
Right.
And we haven't heard a lot of criticism of the district commissioners, but I'm just wondering, is it realistic in the coming years for us to depend on volunteers, or should we be thinking about compensating them?
Okay, so I see two questions then there. One is the quality of the district commissions now, and then payment. There's a wide variation in quality of district commissions. On the one hand, you've got members like Tom Little in Chittenden, who's, of course, incredibly experienced, incredibly knowledgeable, and happens to be a lawyer. And then there are commissioners at the other end of the extreme who may have knowledge, but they don't have the demeanor or the patience, even if they have the knowledge, to provide a fair hearing. So I think there's a wide variation. In general, it's been good, but I think you'd need to ask a lot more people than me for that experience, because my experience is limited to those counties. As far as payment, if people are going to miss work, that's a problem. And I don't know the answer, because you're not going to be able to pay them for missed work. I actually think that what's more important than payment is mandatory training. But payment probably would be nice.
Representative Dolan has a question.
Thank you for your time. You had talked about a canon of judicial review, and I presume you're referring to ex parte rules of
Yes.
communication, which means you can't as you know, can't entertain informal conversations during the court case or the proceeding. We've talked about having a pre-application process, maybe.
Yeah, did you have a good meeting?
I don't see any bruises.
Yeah.
No, it was personal.
About lunch?
John, you were right. I do have a conflict.
You do.
Yeah.